The controversy centers on whether there is already a vacancy at the East African Legislative Assembly to justify the ongoing by-elections. According to Judge Odongo, the answer lies in the interpretation of both the EALA Elections Act and the East African Community Treaty.
The current process, in my view, should only envisage election to replace these members once their term expires in May, once they lose their seats in EALA, which is in May. So whatever is happening right now could be processes leading to the replacement of these members in May.
The two legislators in question were elected to Uganda's 12th parliament, but that parliament has not yet been constituted.
The two members are still members of EALA until such a time when the 12th parliament is constituted and they are sworn in. At that point, they cease to be members of EALA, and that's the point when there is a vacancy and there should have been announcement of the processes to elect new members.
Odongo further clarifies that the concept of nomination in the law has been widely misunderstood in the Ugandan context.
It is different in the case of Uganda. So in the case of Uganda, the word election is the one that suffices. In the case of Kenya, it's dual, because there are those members who are elected and there are those members who are nominated.
A key concern behind the law, Odongo notes, is avoiding what is termed as a dual mandate. This means serving in both national and regional assemblies simultaneously.
Now, both Kakoza and Honorable Namara cannot claim that they are now members of Ugandan Parliament. They don't have that mandate. So their mandate starts on the day when they are sworn in. And that's why, in interpreting that particular provision of the law, you need to have context. You need to have the rationale behind that specific provision within the EALA Elections Act.
A legal question now at the heart of regional representation remains whether Uganda is electing too soon or simply preparing ahead of time. Henry Okrut, UBC.